Hello, Tila. My name is Tracy Hall, Hall, and I'm an attorney out of Houston, Texas. And after 20 years of working as a global strategy consultant, both in the government, our government, and in the private sector for Big Four consulting, and growing my career in HR executive work from compensation through general HR business practices to finally being the global head of talent management, succession planning, recruiting, executive recruiting and coaching, and doing labor and union work for the other side. I decided to go to law school. And with that decision, I went to law school with the sole intent of becoming an attorney for the plaintiff bar. I was asked by T. Maxine Woods out of Dallas, Texas, also known as Maxine, to join her to develop this PowerPoint and to deliver it. But for reasons that we will discuss in the PowerPoint, Maxine is not able to join us today. But she sends her hello, howdy from Dallas. She misses Tila. She hopes that she'll be able to rejoin us soon, and he invites you all to reach out to her. So when Maxine asked me to join her in this presentation, the things we wanted to talk about related to the factors that are impacting the Texas employment and labor plaintiff bar, the opportunity and business outlook, there is one, hang in there, an alternate reality if we don't act, and then finally end with a call to action to evolve and adapt. Now, we planned on delivering this in person. However, given circumstances out of all of our controls, we are doing a recording, or I've been asked to do the recording. So there will be an opportunity for each of us in the call to action to develop some plans on what we can do. But first, we wanted to talk about the factors that are affecting the Texas employment labor plaintiff bar, especially during the 45th administration and what's projected to happen in the 47th. Now, look, I know there are many of you in the audience that have been practicing in this space for 10, 15, 20, 25, 30, 35, 40 years. And thank you. You have so much in your brains that you're going to have to share with all of us. And you may not agree with everything that's in this presentation, but my ask is that you keep an open mind because I purposefully put my MBA business spin on this to lay out some of the factors that are impacting us so then we can understand some strategies. So this presentation may look a little different from some of your CLEs, but my ask is hang in there with us. So, under the 45th administration, look, I know we saw this basically an erosion in a lot of the federal practices, especially at the federal regulatory changes. We saw an erosion in workplace place safety, basically a rollback of some of the Obama era safety rules and the limitations on health and safety claims. Under the overtime rule, we saw delayed and weakened Obama's overtime rule again, reducing unpaid overtime claims, right? We saw a change in the independent contractor rule, resulting in more workers being classified as contractors, which, while may be rewarding for the workers, more money, but it does limit some of the protections. And we also know there were more conservative leaning pro business judicial appointments. I don't have to tell many of you out there, but that our Fifth Circuit has a reputation nationwide when it comes to employment plaintiff bar matters. And also under the 45th administration and locally, we saw some impacts. Cities like Austin, when they sought more worker protections, we know the state blocked it. And while this didn't necessarily happen under the 45th administration, when we think about the Students for Fair Admissions, that act that pretty much did away with affirmative action as we knew it, there was immediate action here in the public universities that expanded beyond some of the Student of Fair Admissions Acts, right? There was a complete erosion at some public universities around any DEI programs. DEI offices were closed down, funding was nixed, employees lost jobs. Now, we're in the early stages of the 47th administration, but some of the things we're already seeing at the federal level is for the NLRB. We currently know that a quorum does not exist. Under the EEOC, we know we have a new person in charge, and that individual is heavily management leaning. Under when it comes to employment discrimination in areas of sexual harassment, transgender rights, race, national origin, and color rights, we're seeing a removal and a rollback of protections under Title VII, right? Especially with transgender, definitely a limitation on gender identity claims will come because, well, there's been a change in the definition of gender. You only have two options. It's become binary, right? According to an executive order. So, look, this is some of the developments that we're either seeing or experiencing. Continue when we think about the hostile work environment claims. We expect a weakened enforcement of discrimination and harassment laws under Title VII. We know there will be, or we think there will be a smaller interpretation of hostile work environment definitions. There will be an erosion of protections for LGBTQ plus workers, right? And then retaliation claims, which is an area that I tend to specialize in, there are going to be stricter requirements for retaliation claims. We're going to see a weakening of anti retaliation protections. And maybe some employers, not that they're very good, some are very good, but not all, are less focused on investigating any retaliation practices. Continuing under the federal and specific developments, when it comes to ADA and FMLA, an area that I also is close to me and I tend to focus on these cases, we will see a reduced enforcement, or I shouldn't say we will, but it's projected, right? High likelihood to challenges for disability protections. In fact, as I deliver this presentation, I think the news story broke that the airlines have already, for customers, starting to figure out or challenging ways to do away, or they want to do away with wheelchair access for their customers. Well, if that's a customer, think about the potential impact on an employee that could be coming, right? Under FMLA, we're probably going to see less enforcement, restrictions on caregiving leave if they're not already tight enough. Here in Texas, I practice a lot in this area, and on eligibility. And we expect to see more tougher standards for proving disability discrimination and or protecting the rights related to disability. And then under EEOC, right, we're expecting to see a more pro-business stance, resulting in fewer investigations and fewer fines. So I don't mean to make this like workforce versus employee at odds, but under this administration, we know, and as someone who has an MBA and is used to working in corporate, we know what good corporate practices look like. And we also in a space, and I know there are many of you out there, we know what bad practices look like. And we know there's always a good balance. But under this administration, we think it's going to tilt more, right, to management side and maybe not so good management side practices across all industries, right? Private, we see what's happening in the federal sector where employees are being terminated through a government organization, that those employees were normally protected by federal unions. But the good news is those federal unions are you leveraging the law, us, to push back, right? Maybe the termination of too many employees in probationary status was not the right thing to do. And having started my career after getting my management science and public policy, from Carnegie Mellon, one of my first assignments was in Washington, D.C. I'm going to date myself, but I own it, under the Clinton Gore reinventing government. They brought in consultants of all ages and experience levels, but we were all trained in public sector, public policy. We knew how to analyze, we knew how to remove the fat. And yes, we did remove jobs, about 20, 30,000 positions. I don't say that with joy and pride, but we all know every now and then you have to look back at efficiency and effectiveness. And we all know there's a way to do it. There is nothing fun, and we know it's being told or seeing someone lose their job. But then to have it done so haphazardly, oops, we didn't mean to, now bring you back. I'm just saying there's a way you can get it done. It's been done before, it's been effective. Okay, enough of reinventing government. Let's focus back in Texas. We know under Texas that Texas is a right to work state. So we know there could be laws coming down that's going to make it harder for folk to unionize or bring collective suits. And again, we've already talked about the impact on local ordinances that may seek worker protections and how the state of Texas has blocked it. And if I'm not mistaken, at the time of this presentation, Texas could be looking to bring its own Doge group in or something similar. And again, having worked in reinventing government, understanding the need for efficiency and effectiveness, there's a way to get it done. But right now, if it's not balanced enough, not enough of us or in there, and we'll talk about that later, impacting those decisions, we could create it well a way and balance that really diminishes the expectations and our protections of the employee workforce. And I will get to this later, but we want to just talk about some of those factors that could be and or impacting the plaintiff bar, right? So for us, this means it could be a shift and a more reliance on our state law of Texas than some of our federal laws. It's going to require more strategic litigation practices on our part, and it's going to require new operating models. How do we work statewide? How do we influence and advocate more in a legislative arena? What can we do differently with our talent and how we hire, groom, develop, and partner? Because it's going to be more increasingly important as federal protections are likely to erode over time that we, the plaintiff bar, really think about how are we going to mobilize and or be more effective, because the employees really are expecting some of those protections, if not all. There's always a time to fine tune, but they're going to expect expectations. There's something, expect expectations on their side. So let's talk about the outlook. Don't pack up. It's not time to retire, because there is a positive outlook for the plaintiff bar. There is an increase in US EEOC charge receipts. So I looked at the 2024 strategic report of the EEOC, and it is available on the EEOC website. So if you haven't been out there, I know a lot of things have changed, but get thee to the data and analytics section, and then get thee to the strategic report. Because in that annual performance report for 2024, once you'll see lots of good data, but also the strategy and the direction of the EEOC effective FY24 through FY26. And there's some good content in there, not only in data, but practices and measurements. But using that data, what I saw or what we saw for FY24 is nationwide, there were about 88,531, well, exact, change receipts. And in the report, it cited that about 17% of those charge receipts led to a reasonable cause, right? And of those 15,000 reasonable cause findings, zero point 0.1, that's not an error, 0.1%, hang with me, I know this is math, resulted in the EEOC filings at a national level. So what happened to those other 13,541? Well, that's a good question. The chances are they went to the states. And what did the states do with them? So what I'm saying is there's an opportunity out there for us nationally. Now, that's nationally. What about Texas? In the state of Texas, we're also seeing a positive outlook. Now, using the most recent data that I could find from the EEOC website, there were about 75 million employees in the United States workforce. And in FY 2022, Texas was number two. Now, if you follow trends, we know that's more likely to change. This is because Texas is the fastest growing state. It's projected to continue to become the fastest growing state in population. And with that growth will be an increase in our workforce. Now, where are the people coming from? You could say internationally from South America, right? We know we have that. We're an international hub. Maybe I'm down in Houston, but we know we have international populations coming in from Africa, from Asia, oil and gas, right? But statewide, we also know people are moving from California, the Midwest, Ohio, Detroit, Michigan is the state, Detroit's the city, Illinois. We know they're coming over from Florida, and they're coming over from the Northeast. But check this out. We may know that Texas population is growing, so we were number two on the employee count. But look at this. In FY24, Texas had the largest number of EEOC charge receipts across the nation. I was surprised to see it because I just knew it would be California. Maybe I wish we were in the room. Someone may have some insights. But think about it. Texas had the highest number of EEOC charge receipts. So these employees that are moving from California, from Illinois, from Midwest, Ohio, Union areas, right? The Northeast, more high cost living, but more employee friendly practices, they're bringing their expectations to Texas. That's one theory. But if you hang with me on that theory, then you'll hang with me to say, you know what, there is an opportunity. The business outlook looks pretty good, pretty bright, right? And so we did some quick math. So using data from different places, if we look at the charge receipts for FY24, now notice the national was 88,000, right? I used the reasonable cause from the percent was found to be 17%, and that came from the strategy report. And then on app, rounding up, it was about 150 filings. Now, if we applied those same formula, assuming it worked in Texas, Texas had 9,328 charge receipts, right? Applying the 17% national average, I couldn't find the specific numbers for Texas, but so I used the 17% from the national. That results in about 1,586 reasonable cause findings. So, just doing the math for FY24, that means that there were about anywhere from 0 to 1,586 potential filings or cases for the plaintiff bar. Now, you can sit back and say, now, come on, not everybody can afford an attorney. Not everybody is a serious someone I want to work with. And you're right, but the potential is there. Notice we started in the beginning, a call to action, and how do we do this differently? But the good news is just going with this, looking at the factors, both from the 45th and now the 47th administration, there are expectations for of the employees in Texas for protections, which means there is opportunity for the plaintiff bar. Okay. So this just summarized the opportunity in business look. So look, if you're still out there, you're still following me, you are understanding the gist of where we're going, you see an opportunity remains. But that opportunity only remains if we remain active, right? So this is my slide from Maxine. She wanted us to understand we cannot check out now. It's easy to say my practice will be fine because this is my niche. Or my practice, I will be fine because I'm 1, 2, 3, 4, 5 years from retirement. Or my practice will be fine because, well, I have a good network. It's small, but it's mighty. Or I'm going to be okay because, well, I mentor and sponsor 1 to 2 new plaintiff bar members each year, or I hire interns. But did you just see the statistics on the other page? We think there are about 1,500 cases out there. So I couldn't find the data on the number of us who identify as being active members of TILA and or the plaintiff bar. But if we continue to grow at 1 to 2 or 50 new attorneys each year, will we meet those market needs? Will we be able to fulfill the opportunity? So that's why we're saying don't check out now, because if we check out, it's going to lead to a mindset that we've chosen a binary proposition, right? On how we're going to continue. Either we're going to make it or we're not, right? And or if we check out now, employees may go, there's no real protection out here for us. It's going to be up to us to get the message out that you still have employee rights. You still have employee laws. We're going to have to do more advocacy than we're probably comfortable with. But also, more importantly, we got to get the message out, and we have to show the management side that, hey, we're not going to be easily run over. We are still here despite the news that comes out about the erosion of this, anti-DEI that, no woke this, no job protection LGBTQ, no disability protection. No, we're going to have to really stand up and think about how do we do this differently. Otherwise, this alternate reality that Maxine has reminded me of will become true, right? We will fade. So, again, summarizing, the opportunity exists, but it's going to require us to do something different, a different operating model, right? How do we serve the employees across different incomes? How do we keep our cases in state court? Anybody can say defeat the motion of summary judgment. How do we stay current, right? How do we implement and advocate state legislations, right? So this section is where we move to what's called the call to action. It's time to evolve and adapt. And again, we prepared this more if we could be there, talk with, engage. So I know this one-on-one through the screen may feel a little odd, but just work with me on this next section. So look, the call to action and adapt, call to action. We must evolve and adapt, right? So what can the plaintiff bar do? What must we do? And so this is the substantive part, right? Focus on state specific claims. Develop an expertise in emerging issues. Think about the gig economy, those independent contractor misclassifications, they still exist, right? Remote work issues. How many times have you heard, and it still bothers me, I've been working remote since those wonderful Clinton Gore days, but it just, you may say, how did you work remote? There was no such thing called the internet. We didn't have Zoom, and you're right. But we knew there were days we never reported because for the global firm that I was with, we reported to a remote work site. I didn't go into the office. The team I joined at the remote work site weren't my daily peers. They were coming from different parts of the country based on their expertise. We met over there, did our thing Monday through Thursday, reported back to our official office on Friday. So think about those remote work issues, the perception that if you're not at your desk in an office that you're not doing work, right? We are going to have to stay focused on disability accommodations. What things can we do to strengthen discrimination and harassment claims? Focus on that niche. Look at the racial, gender, as it relates to hostile work environment and harassment claims, right? Maybe it's no longer an issue of hiring and termination. Maybe it's some of those claims in the middle, things related to performance management, right? The bias, the discrimination in who's getting promoted, the hostility at work, right? And also think more about businesses for training and compliance programs from an employee stance. Speaking of that, think about getting out there. We're going to have to get out there and where the workers are. If this is your thing, have you gone to the union hall? Have you called a meeting? Arrange to meet with employees, not to necessarily collectively organize, but just help employees understand their rights. Because as much as you turn on the news and you hear this is gone, that's gone, DEI, how it's all been warped in definition, and it went from something expanding the talent net to um, restricting it, right? I mean, an airplane crashed, and the first thing you heard it was a DEI, right? And also think about, as you think about harassment, I mean, the tragic death of the firefighter out in California. That how did that play out in her workforce? Think about retaliation claims. So this is a lot of substance, and I know for as attorneys, we're going to figure this part out. One of the things we really wanted to call attention to is how do we evolve, and adapt the bar itself, right? How do we apply, and this is where I get to have some fun and apply my talent management and succession planning from other organizations to really build and sustain for the plaintiff bar. And I'm distracted by space, and I'm so sorry. For the plaintiff bar, a talent pipeline. Now, look, we know we can't always rely on the graduations or the bar placements, right? And we know we're going to have to do something more than just hire one or two associates each year if we're going to keep up. So, have we established a TILA data and insights database to really understand who we are? Where do we work? What's the concentration of ADA attorneys in Austin? What's the concentration of retaliation in Dallas? What's the concentration of FMLA specialty employment bar attorneys in Tyler, right? We're going to have to think about that. Who are we? Where do we work? How many years of practice experience? What's our expertise? Not only in the law, but who are the advocacy experts, right? Who are the experts around running effective practices? Who are the experts in litigation, settlement? So once we understand more of who we are, oh, other thing, who's planning to retire, right? So once we understand who we are and where we are in terms of years of experience, we can better gauge how many people should we be, I don't want to say hire, but attract to the space, right? Who do we groom? Who do we mentor, which is number two? Design and implement a new plaintiff bar mentor program. Borrow from other bar groups. I know Reptil has a beautiful model. People apply to become a part of the Reptil Leadership Mentor Mentee program. If they're accepted, then they go through, it's like I think a year and a half with mentors. They have homework assignments. They have to pass certain CLEs, right? The different areas of practice. So more formalized programs, and it's not always focusing on the young lawyer or the person who's been practicing under 5 years. It's focusing on across the board, people under 10 years that want to get better in this space. We can also leverage Texas bar resources, right? Another way to evolve, network across different metro and rural areas. While I know I'm in the Houston area, Tila, Nila, I know there's a Dallas, and thanks to some other people, I participate in a lot of Dallas TILA. But do we really work? Like, how often does Dallas work with San Antonio? I'm sure San Antonio and Austin network, but time to really get more formalized in our network so we'll know who's who, who's what, and who's doing what. And then, of course, there's always technology to help with knowledge sharing. So, for that one person who really nailed I think one of the best things I appreciated is with Sanford, BB Sanford, when they had an open webinar, I believe, and let us understand now what really happened in that FedEx case, or we were invited to hear the hearing at the Fifth Circuit. And then finally, one of the reasons I said Maxine couldn't join us because she had to make a tough decision to close her practice for a little while and go work outside of TILA and go management side. So share firm funding resource information, i.e. ABA bar fellowships in this space or state or national union related grants. so we can really sustain. Again, this is not a tell, and I hope it doesn't feel that way. It's kind of awkward when I'm looking at a camera. But we really want us to start saying, aha, if we're going to sustain, we're going to need more people. Okay? Um, so this is where, as I approach a time limit, where we decided that look, for each of us to it's time for us to think through in our own capacities, for us to develop and implement a 30, 60, 90, maybe 1 year personal plan to involve and adapt TILA from our personal perspectives. And be sure to add measurements, because what's measured gets done. Things we could think about is, who are you networking with? Who you reached out to? Mentoring to me seems, oh, I know when people would ask me, will you be my mentor? I went, no, because I don't know what I'm doing. But the question is, who can you talk to? Who can you share some of your battle tested stories with, right? Who are you allowing to shadow you during the day? Maybe there's a deposition coming up that you can invite someone to shadow in that area so they can see how this works, right? Maybe there's a way with the litigation, and I know it's very complicated in litigation, but invite someone to attend your trial, right? So think about that for your action plans. So in conclusion, we're saying with this PowerPoint, we hope it, again, frees your mind to start thinking, wait a minute, we see what we're hearing and seeing, but there is opportunity. Texas is going to grow in its workforce population, and those expectations of the employees, they're real. But we've got to figure out as our bar, if we're going to evolve and adapt and not face that bleak reality, how do we serve them? They're going to have different incomes. Do we always say the retainer is blah, blah, blah? Or do we always rule out the case that won't come to XYZ because of the attorney fees? I remember the case where it was, I believe, in the Northern District Court, where it was I think it was a wage and hour claim, and the attorney's fees were high, but the judge awarded those attorney's fees. So how do we do more of that type in our practice and build that into our business model? Okay. So again, these were just thoughts that we wanted to share. And if we were there, we could interact. I hope you found this interesting, if anything, insightful. And hopefully, if it was you challenging or you have some comments, here we are. Feel free to contact us. Again, my name is Tracy Hall, and I am out of Houston, Texas. And while I've worked, I'm going to own it during the Clinton and Gore administration in DC. I actually became licensed, one of my proudest moments, to practice in Texas in 2017. And then we also have Maxine Woods. So reach out to us. Thank you for the opportunity to present, and hopefully we will see you all soon. Bye-bye.